I know. He took the prep. He's a young dude. He's 27. He's one of 1,000 VP.
I don't know.
Yeah, I know. I mean, I haven't made my quarter. And only then, oh yeah, she has
This was
even the station no noticeable errors is how it puts it. No noticeable errors. Noticeable errors, right? I had one yesterday. Moderate. One time I was in the prosecutor that said he could tell by the smell of she had. I lost right when someone said. I think he was legit thinking that he could. All I know is what he said. I had my hands. And then they confessed when he wheeled him in. So what is 10 feet? What are 2 feet? What is the difference between 10 and 10 feet or 2 feet?
Good morning, everybody. My name is Carol Wagon. I'm the director of the Center for Advanced Civil Studies here at Suffolk Law School. On behalf of the center, I'd like to welcome you all here this morning. We delayed just a little bit to give people time to get in because of the snow, but we do want to get started now. Just a couple quick announcements before we begin the program. Kevin Reddington, who was supposed to be on the morning part of the program, is arguing a murder case this morning, so he won't be with us this morning, but he will be here for the afternoon. So he will be here for the demonstrations and examinations this afternoon. In your books, you received a little card that says Save the Date. And we just wanted to let you all know about a program that we thought you might also be interested in that's coming up on Thursday, April 8th. That is also a Matt Wellness Institute program, and it's going to be on difficult issues in district court practice, focusing on discovery issues and mental health issues. So if you'd like some more information about that program, you can see me or go to our website or just give us a call. I do also want to take this opportunity to encourage you to fill out the evaluation forms that you received with your materials. We welcome your comments and suggestions on this program as well as suggestions for future programs. You can either fill that form out during the course of the day and then leave it at our registration table, mail it in, fax it in, or you can go on our website and fill it out there if you prefer. It's now my pleasure to introduce Justice John Irwin, who's the director of the Matt Wellness Institute for Trial and Appellate Advocacy here at Suffolk.
Good morning, everyone. As Carol pointed out, I happen to be the director here at the Law School of the Matt Wellness Institute, which is sponsoring this particular program. And really, all I want to do very quickly is thank you for your participation here today. I think you can probably understand that this program, if you've taken a look at it, is not only timely, but certainly is a program that has the benefit of a terrific faculty that has been put together through the hard efforts of Dick Sisson and Carol Wagon. And so I am grateful to all of those members of that faculty because, as you probably know, they come here at great inconvenience to themselves and not only today, but in many other days in preparation for it. So I hope that at the end of the program today, you'll be able to agree with me that it indeed has been a very worthwhile program that has been presented to you in really a very wonderful way. So thank you all for being here, and we'll get the program going right away.
And I'd like to introduce the chairperson of today's program, Richard Zisson from the law firm of Zisson Vieira, and a member of the adjunct faculty here at Suffolk.
Morning. By show of hands, can I get a sense of how many of you have been in practice less than 5 years? Okay, so it's about half and half. Because I recognize many of you as either former students or advocates that I see in the court, and I know that some of you could actually be up here on this panel teaching this stuff. And when I was asked to put this program together, it couldn't have been more timely, because as of July 3rd, as you know, the law changed. And you would think with such a drastic change in the law that there would be training for the court, training for the lawyers, everyone getting used to what this law is all about. But it doesn't work that way. That's not the way the world works. And it's ironic, this law came in July 3rd of this past year. And on July 5th or 6th, I was having coffee in my local coffee shop with a local district court judge. And he is reading vigorously through the memo, which you have in the materials, from Judge Zoll dated July 2nd. And I'm saying, is this a quick learn, or is this, you're gonna give a lecture on this someplace? This is the first time I've seen it. And I'm looking through the various things, and it's very, very confusing. There was a crying need for this seminar. There are seminars given all over the state now on this law. I think ours is the best because it balances not just a talk on the changes in the law, but actually the application of some of this stuff. You'll see a cross-examination of a police officer, which is probably the heart of an OUI case, and a direct of a toxicologist who we have. We're honored to have David Benjamin here, and you'll hear all about him as the program goes on. And he'll tell you some stuff about this machine. Had I known about these facts years ago, I would have used them long before that. But now where we have this per se business, and the legislature is trying to make the law into a speeding ticket. In other words, if you had a .8 or above, you're guilty. We're here to stop that from happening and to test that, and to make sure that we're able to defend our clients vigorously with the tools that we need. So, without further ado, we're going to have a discussion this morning on the law itself. How does it work? How can it be challenged? What are any other litigation strategies? George Hassett, you all know, I'm sure have seen in the courts, an expert, excellent practitioner doing defense of drunk driving cases, OUI cases. Reddington will be here, and it's too bad we can't make fun of him because he's not here, but when he comes, we'll have adequate time. He's arguing before the Supreme Judicial Court a murder case, and he said to the family, do you mind if I submit on brief so I can talk at Suffolk Court? They said no. So he's arguing a murder case before the Supreme Judicial Court. He will be here. And we're honored to have Bob Rufo as part of this particular panel. Judge Rufo is a justice of the West Roxbury Division of the District Court, and his colleague, Judge Coffey, who is not a Suffolk graduate, by the way, but we allowed her in the building because she has such expertise in this work matter. Rufo, I'm old enough to say Rufo was my student, so it's Judge Rufo. And we'll go on with that particular panel. In any event, Sandra Gosser is here as well, and she's a former supervisor of district attorneys in Suffolk County, and she has a prosecution orientation, but we'll let her again participate. During this discussion, if you have questions, we'll try to take your questions and address your concerns as they occur. So I would like to start with Judge Rufo. If you could give us a little overview of how you view this statute. Sit here.
Okay. Good morning. Thank you, Professor Zisson. I am old enough to say that Dick was my instructor for criminal trial tactics, and a lot has changed since those days in the 70s when I had the privilege of attending this law school. And I know that he stayed abreast of the law, and all of you are trying to do the same as we are. And as Dick said, there's been absolutely nothing other than the memo that we included in the packet from Chief Justice Zoll concerning the new law. So we're sort of trying to figure out what to do as we examine the new statute and try to pick it apart, trying to figure out what the legislative intent was. So what I'm going to do right now is just spend about 5 or 10 minutes discussing it from my perspective and pointing out some of the intricacies of the new law. And as I prepared the materials for today, and George was just teasing me about it, we gave you what we got from the District Court Department in your materials, which is a annotated version of Chapter 28 of the Acts of 2003. And it's an excellent little tool. You should throw it in your briefcase if you have an OUI, because it's a quick reference and it shows you where the law changed, with that classic striking and deleting language. And it starts off, it says OUI related statutes and regulations. It's in your materials. And that in and of itself is worth its weight in gold, because as many of you know, when we try to read a statute that's newly created, we're trying to figure out where the changes are, and this gives you that quick reference. So it's something that I think will be of assistance to you as you begin to prepare your strategies, whether it be from the prosecution or the defense perspective. Anyway, on June 28th, actually June 30th, Chapter 28 was passed, 5:36 p.m., getting ready for July 4th weekend. And it's created the so-called .08 per se inference in operating under the influence of intoxicating liquor or alcohol. And what the statute does is it raises the following question. Is this one offense that incorporates two separate theories of criminal prosecution, or was the legislative intent to create two separate offenses now that the prosecution can advance in the prosecution of and operating under the influence of intoxicating liquor under the so-called general way, the under the influence perspective, the elements of that, or do we now have this new technological approach, which is the .08 per se, assuming that we have a breath test, of course, where no evidence of actual impairment is necessary to be proven for the defendant to be found guilty under this branch or theory of OUI prosecution. So how do we answer that question? Well, as always, I think we have to look at the wording of the statute to try and determine what the legislative intent was at that time of the passage of this new law. And I have found a couple of clues that I think indicate that this is one offense with two possible theories of culpability. Again, this is my view. The first clue, I think, is to take a look at Section 3 of the new law. It's in page 10 of your booklet. And what Section 3 of the new law does is, you'll see, it strikes and eliminates the so-called permissible inference that could in the past be drawn if the defendant was operating under the influence and his blood alcohol or her blood alcohol content is 0.08 or greater. Now, by striking this language, the new law instead creates a statutory inference that the results of the breathalyzer test is admissible and relevant to the determination of whether the person is under the influence of intoxicating liquor. So that's, I think, a huge clue in terms of looking at it. Now, with reliance on technology and administering breath tests, and today we're going to see a lot of information about that, there's going to be a far greater focus on the reliability of the breathalyzer machines. And I'm told that the defense bar in the future is going to have access to breath test results online because there's a central computerized database where all this information is being stored by the authorities, and that there's an actual website for this. So I can see Dick Zisson now on weekends cluing in to see if his neighbors have been arrested for OUI so he can approach them and get them as clients. They're going to actually allow access by defense bar to call up the information and even have access to the police report that goes along with it. It hasn't happened yet. I checked yesterday with the registry, and but they're actually setting up a database in a way in which you can check online. Now, the second clue in examining legislative intent, I think, comes from an examination regarding the reduced period of a loss of license for those who take and fail the breathalyzer test. Look what happened here. If you take the test and fail, this is on page 12 of the materials, you lose your license for only 30 days. And they have increased the penalty correspondingly. If you don't take the test, if you refuse to take the test, it's an 180-day license loss. That's on page 11. So the statute authorizes as well a hardship license, even on a 24D disposition, which prior to June 30th you couldn't get. Now, some defense attorneys think that the net result of lowering the penalty for taking and failing the test, coupled with the hardship license, gives them a little more breathing room because they can get their client back behind the wheel, and then they can explore more valid defenses to this particular offense. So the hardship provision being relaxed, I think, again, shows what the legislative intent was. Now, I am aware of some interesting behind-the-scenes discussions that have taken place since the passage of the new law from among the judiciary as well as the prosecution and defense. And some persons, even in the judiciary, are of the view that we don't have to answer the question at all that I pose, which is this one offense with two branches or separate theories of prosecution, or is it two separate offenses? And one solution that's been offered, has not been adopted, but has been offered, is that we should sever the complaint language into two separate offenses, depending upon the factual circumstances of every individual case. Now, this would require separate complaint language to be drafted and then incorporated into our district municipal court complaint issuance procedure. Now, these individuals who are behind this theory think that this approach will eliminate some of the confusion. It would also require, of course, the drafting of two separate jury instructions depending upon the Commonwealth's theory of prosecution, the so-called under the influence or .08. Now, the other view, which is also held by the Mass District Attorneys Association, also my view, that the new law does not create two separate and distinct offenses. Now, I think this comes really from an examination of that tiny word "or." If you look at the heading of the statute, it's operating under the influence or with .08. So we've all read statutes before, and we know that that tiny little word "or" doesn't say "and," it says "or," gives us a clue, again, that this is one statute with two separate theories or branches of possible prosecution that the Commonwealth can advance. Now, can you imagine the confusion that could be caused by having separate complaints issued under each theory, especially as it relates to the now lifetime look-back provision in the statute? Now, if the offenses were separate, I can hear Attorney Hassett here saying, well, Judge, that's a separate offense. My client, when he was in college, may have taken a quaff 30 years ago. It doesn't apply. It's a separate offense. So it would really wreak havoc with respect to the penalty phase of any prosecution if we separated them out and bifurcated it in that way. And of course, the DAs want to look back as far as they can to increase the penalty resulting from prior convictions, even an admission that was made 25 or 30 years ago. Now, the defense bar is salivating at all of the confusion caused by the speedy passage of this new law because, of course, the more confusion, the greater chance for a judge or a jury to become totally befuddled and not in unanimous agreement to convict. You should have seen these two at our preparation meetings, talking wildly at the confusion that's already been caused by the passage of this law.
We don't have a life. This is what we talk about.
And from my perspective, this confusion creates very ripe appellate issues for those trial judges that are laboring in the trenches and trying to decide what to do with some of the more creative motions in limine that have already cropped up. Some of them are in your package right here, and we'll get to those later. And the fact that we don't have an amendment to the model jury instructions up to this point in time. None have surfaced since the passage of the new OUI law. Now, by way of those motions in limine that I referred to, and Judge and Dick are going to get into them heavy, judges now have to decide, and we've already had this happen, how the Commonwealth will be permitted to proceed with criminal prosecution. If there's no breath test, that's easy. Then the traditional OUI prosecution will proceed. The old model jury instruction with some modification will suffice in most cases. In cases where there is a breath test now, and it is admissible, the Commonwealth may or may not be limited by the trial judge in proceeding on a singular theory of culpability. And in my view, again, the cases where the prosecutor is permitted to advance both theories, if that happens, judges are going to have to draft some sort of bridge instruction to preserve the unitary charge in order to properly guide the jury and focus them on the particular theory that the Commonwealth is now advancing in this particular case. Now, I took the liberty of just drafting a bridge instruction. It's not perfect, but it's something that might go like this. We'll start and say, jurors, the defendant is charged with operating a motor vehicle while under the influence of intoxicating liquor and with operating a motor vehicle while having a percentage by weight of alcohol in his or her blood of 8/100ths or greater. You must consider each of these two theories separately and return a unanimous verdict of guilty or not guilty on each theory. I'm now going to instruct you separately as to what the Commonwealth must prove beyond a reasonable doubt as to each theory. Again, then I'd go into it, the OUI under the influence, the OUI .08. Now, this approach is going to require a special verdict slip where the fact finders are going to have to state the theory of culpability in which they have relied in finding the defendant guilty, if they find the defendant guilty. And the jury is going to have to agree unanimously on the verdict and the specific theory of culpability. And this could be really important, especially if the case goes up on appeal or a motion for new trial. So judges are going to have to craft a special verdict slip if that approach is taken. Now, as I said, the model jury instructions have not been updated as of yet to comport with the enactment of this new statute. And as practitioners, you certainly would want to consider submitting proposed instructions to the judges on your particular cases and verdict slips as well before the case even gets underway by way of motion in limine, so that we can have an opportunity to discuss how and what approach the Commonwealth will be permitted to take in your case. So I'm going to end there with my remarks and ask either Judge or Dick to pipe up.
Thanks. Judge, can you comment on some of the things that Judge Rufo addressed?
I respectfully disagree with Judge Rufo. I think two separate crimes have been created. From a practical point of view, I think the first thing we have to do as defense lawyers is go directly to the charging document. When you look at the charging document, you're going to look for the two things. It's now a new complaint. It charges in the alternative. I know of no other crime that charges in the alternative. And so now we have a complaint that charges you being a person with a .08 or above, or being a person while under the influence of alcohol. I think that's two separate crimes. I disagree with Judge Zoll. In your package, at page 71, Dick has prepared a motion, and it's called the Defendant's Motion for Notice of Intent. And we can bring that before the court and ask the judge to order the Commonwealth to proceed on one of the two theories, whether or not the person is a .08 or above, or whether or not I'm a person who's under the influence of intoxicating liquor. Once we preserve that issue, number one, our backs are covered as far as being defense lawyers, that we've preserved the issue, we weren't ineffective. We forced the judge to make a decision as to how they're going to proceed. Now, if the Commonwealth decides to proceed, it has to be a breath test case. If the Commonwealth decides they're going to proceed in the charge of being a person with a .08 or above, then it naturally flows from that decision that you can file a motion in limine requesting the court to exclude any evidence of observations of the police officer as to red and glassy eyes, strong odor of alcohol, he was unsteady in his feet, he failed the field sobriety test. Because in my opinion, those observations and that information has no relation whatsoever to the element of whether or not you're 08 or above. So you're putting the Commonwealth in a position that you're putting the machine on trial. And I think it's excluded. There are two motions in limine included in the package. They're basically duplicate. One is where you basically get the Commonwealth, you stipulate to operation if there's no operation, because if you stipulate to operation, now the observations of operation are not relevant because they've proved operation and everything else is out. It's down to whether it's an 08 or above.
By the way, the issue of whether or not prejudice outweighs probative value is key. In other words, if they have to prove a .08 or above and they have a machine that has a reading of a .08, who cares if the guy had a strong odor of alcohol? It's irrelevant. The issue is whether or not he had a .08. And who cares about his eyes? The issue is whether or not he had a .08. So the motion in limine would seek to exclude as entirely prejudicial, outweighing any probative value of whether or not that person had a .08, keeping in mind that it's not a crime to drive after drinking in Massachusetts. If it was an absolute prohibition of drinking after driving, that would be relevant. But with the issue is whether or not it's a .08 rather than a .07, it's highly prejudicial, outweighs probative value, and that's the basis for that motion to exclude. If they elect, and I'm suggesting they have to elect as well, I agree with George, if they elect to go with that part of the statute.
So assume the judge makes the error and he says, and he or she says, I'm going to let them proceed on both theories, okay? Now we're in a position where, once again, you want to preserve the record. You don't want to come back here that you were ineffective assistance of counsel. I've drafted a defendant's, it's going to the jury on both theories. So I've drafted a special verdict form. I've never had a special verdict form in a criminal case. So if you take a look at it, we've got that, okay? You've got the judge has made the mistake. It's going to the jury. Everything's coming in. Okay, Judge, here's your special verdict form. We give it to the judge, and we're preserving the record at all times. Now it goes to the jury on both theories. Now as a defense lawyer, you're fighting the Commonwealth on two fronts. You got two charges in front of you. They're not in a separate complaint, and I think you have really a duty to request defendant's motions for specific unanimity instruction. I took the model jury instruction and kind of put something together.
It's on the page, Judge.
Page 79. Page 79 on that motion. Now, I think the court will give it. I don't see any reason why they wouldn't give it in their own form and they'd adapt that. I think the interesting part then, if it comes to the issue whether the Commonwealth has elected to go with it, just the 08, or if it's going both theories, there's no jury instruction on what it means to be a person with a .08 or above. I took the model jury instruction for operating under and kind of just drafted around it. And I think it's real important on a breath test case. What does it mean to be a person with a .08 or above? Well, members of the jury, what it means to be, what the Commonwealth has to prove beyond a reasonable doubt as to whether or not this person is a .08 or above is the following. Now, I think what's important in the language, and you can adapt it either way, that
Page 83.
83 and 84, is when you look at a breath test case, go back to the whole premise of breathalyzers. It's the assumption that everybody has the 2100 to 1 ratio. So that's an assumption. So I think the real important sentence to include is that this specific, the Commonwealth has to prove beyond a reasonable doubt that this specific person was .08 or above, because
By the way, not that the machine said .08 or above. Don't be confused, because the fact that there's a reading of a .08 or above does not make him or her automatically guilty. Otherwise, we would do this whole process by computer. They wouldn't even have to go to court. They'd stay in the police station and be sentenced right there. The point is that .08 on the machine is just evidence of, and after you hear, keep an open mind, after you hear Dr. Benjamin, you will be able to relax about the significance of that number.
now on the 08, because on the assumption, it's based on the assumption 2100 to 1. And if you can, I think you wouldn't even need an expert, sorry, doctor. Because if you can get the manuals, and you can get the officer, the operator, to admit that he went to the X number of hour course, that during the course he took tests, that during the course he learned the basic workings of the machine, and that he learned that it was built on the assumption of 2100 to 1, and you get that in on the cross, then, and you get it in that that's an assumption, and you don't know what this Mr. Jones's blood alcohol ratio is, do you? You don't know if he's a 2100 to 1, do you? So it's an assumption, and if the judge gives that specific, you must find that this specific person is 08 or above. You've at least got something to go to the jury and argue, and you can fight this 08 you presume to be under the influence. I don't know what an 08 is. I think it's an argument if they go that way. I think it's void for vagueness as to what an I don't know what an 08 is. I think they should define what an 08 is, but that's for another day. Now, I mean, I think you go to the complaint, and everything goes off that complaint. And if the court makes the error or makes the decision that it's going to go in, we got to cover our backs, and I think you have to file the motions, ask for the specific unanimity, ask for the instruction on what it means to be a .08 or above. Those motions are included in the package.
I'd like to point out something that George said. If you look at page 53 in your materials. Now, I have to admit, in front of two judicial officers, that my theory of defending one of these cases is no case before its time. So my cases that started last July and the successor cases haven't yet come up for trial, because I spent a lot of time, and we'll talk about discovery. It's critical in these cases. And so I haven't yet addressed this, but I am starting to file these motions. What you're asking the court to do is to compel the Commonwealth to make an election. In other words, you're raising the whole issue as a matter of law well before the trial. And I'm asking a motion judge, not a trial judge, to do that. In other words, I want to say to the court, look, do I have to get Benjamin? If I do, I want to know it now. Is this a .08 case, or is this a standard vanilla ice cream OUI case? Because I disagree with Judge Zoll. And Judge Zoll, in his materials, and it's the second set of materials that is in your packet. It's on page 31. If you look on page 31, paragraph 1. That's the memo that I had coffee with a judicial officer about on July 6th. And if you read paragraph number 1, it says the statute does not create any new offenses. And I agree with George. I suggest he's incorrect. It's not been tested by any appeals court. And you can, in good faith, take the position that there are two separate offenses created here, and the jury has to be instructed and sort them out. I'm asking the court to order the Commonwealth to make an election. Now, whether they do it or not, it depends on the particular judicial officer. But the question is, when do you file it? Do you file it the day of trial, or do you file it up front? And there's some tactical decisions you have to make. Do you tip them off that you're going to be using the expert? These are things that you're going to have to weigh depending on what particular jurisdiction you're in. But I would suggest that you have this motion in every case so that You can argue, if the Commonwealth agrees with you and says, this is a .08 case, fine. You then have your motion in limine ready the day of trial to exclude everything other than evidence of a .08. That this is a machine case. This is not a case about slurred speech. This is not a case about glassy eyes. This is a case about whether or not, through the wonder of science, they can prove that this person has a .08 in his system, even though the machine might say something like a .12 or a .16.
Dick,
Yeah.
just a quick response. As you can see, we're disagreeing right off the bat as to whether this is two separate offenses or one offense with two theories of possible prosecution. This is not the first time that we've seen this. If you take a look at assault and battery, and Judge Coffey and I were talking about this last evening, in an assault and battery case, we have intentional assault and battery, and we have reckless assault and battery, and the Commonwealth can proceed on either theory. And yes, we would prefer that they advance the theory of prosecution in advance so that we don't confuse the jury. And in that case, for the most part, the prosecutor is bound to make an election as to what theory they're going to advance in terms of that prosecution. So it's one singular offense, assault and battery, with two possible theories of criminal prosecution. That's just an example of an offense that the prosecutor right now has that opportunity to go forward, and there is case law on that.
And I think the case law that's similar is on the first-degree murder cases where there's the third prong. It was a cruelty, an atrocity, or was it committed during the commission of a felony. They're saying that that goes to the jury, and they don't. The government doesn't have to elect that. Those are the ones that lawyers have said to me where my theory is wrong on those cases. I haven't researched that issue real thoroughly on that type of case. But there's a strategic issue here for defense lawyers. And we hate giving it up if there are DAs here. But when you make that decision, you might not want to file that motion. Because if you have an 08 or an 09, you might want to stick with that 08 or an 09. Because in my opinion, if they go on the two theories and it's an 08 or an 09, I think the defendant is entitled to a required finding and not guilty on an 08 or an 09. Because if you cross the breathalyzer officer and you've got your manuals and you can examine him, that the reason why the two tests have to agree within a plus or minus 0.2 is because there's a plus or minus 0.2 margin of error. And it's going to be in his manual, it's going to be in the breath test manual. So when you get to those close call cases, that 08 can be as high as a 1.0, or that 08 can be as low as an 06. I think there's a real solid argument for it, and if you can go with the basis and do it on cross, I think it's a solid motion for required finding. And you might not want to file your notice of intent to have them separate out the charges. So strategically, you might not want to do it depending upon what the test result is. Now, the other scenario that you can imagine is the government says, you know what, the defense lawyer's right, it's an 08 or it's an 09, we're going to proceed on the theory that he was under the influence of intoxicating liquor. We're not going to proceed on the first prong of the statute, but we're going to use the breathalyzer result. Okay? And
As they had before July 3rd.
as they had before. So we're not going to go on the per se. We're going to go with the under the influence of intoxicating liquor, but we're going to use the breathalyzer evidence, and we're going to request the court give the former instruction that an inference can be drawn. I have a motion in there requesting the court to exclude the breath test. The way I read the statute, on this one, I tend to agree with Judge Rufo, that I think they can do it. I think they can choose under the influence of intoxicating liquor, but they can use the breath test evidence as some evidence of intoxication and request the court instruct the jury on the old instruction. So, strategically, you want to watch how your case unfolds as far as that complaint.
Sandra, as being a former prosecutor, and I assume that you have a bent toward that, could you tell us how you view this, and how would this impact on you if you were still the supervisor for district court prosecutors in Suffolk?
Well, certainly, I think with respect to the charging language, and also with respect to whether or not a new crime is created, my position would be that it does not create a new crime, and that the Commonwealth could proceed under either of two theories in proving simply operating under the influence, whether it be by a .08 per se, or that the defendant was under the influence of alcohol. Certainly with a notice requesting an intent to charge, I would suggest the Commonwealth's position being that to always go, for the most part, with both theories, and to argue that both theories simultaneously could be proven, and when it goes down to the jury, that certainly a bifurcated jury form could be given out under which theory the jury unanimously found the defendant to be in violation of the statute. That being said, certainly it would make sense, and responding to my brother, at any time when there was, say, a 1 or above, the Commonwealth would obviously perhaps lean toward the per se election if that were forced. Any time that it were a 0.9 or below, obviously the Commonwealth would lean toward going under the theory that the defendant was operating under the influence. And as George mentioned, under 24(1)E, which is on page 10 of the materials, that is, throughout the statute, a permissible manner in which the Commonwealth could introduce evidence of the breathalyzer to the jury as some evidence of the defendant's intoxication. And certainly, I would suggest that my brother's motion, in that case, to exclude the results of the breathalyzer test when the Commonwealth was seeking to elect under the influence theory would probably not be successful.
Thanks. If you look at the statute from how it impacts on your practice, and this is what we are here for. I'm not on the Commonwealth's payroll. I'm not a judge. I'm not, in this context, a law professor, although many of you are my former students. I'm looking at it as a practitioner. And as a practitioner, I clearly see what the enablers of this legislation were all about. They want to make, and it's even referred to by Judge Zoll in his memo, it's very revealing, the attitude of this thing. They want to make a first offense almost like a speeding ticket. And they want to make it so obvious to a defendant that they should plead out on the thing. You get your license back in 3 days because you have to wait, you have to enroll in the program. I'll explain a little bit about that to you in a minute. So it's a real significant disincentive to go forward with trials. And he even says it. And that way we eliminate jury trials and we got him for a first offense. I mean, it's in there, and in his own memo. As if that's something that you want to try to achieve, even though the person might not be under the influence. So I have a difficulty with the motivation. Sure, it puts stuff through the pipe, it alleviates court congestion, and I'm sure that both judges, Rufo and Coffey, will admit, although they don't get that many, I've learned that they don't get that many OUI cases in West Roxbury. They have spent too much time with the armed robberies. So they don't have time for this, but they don't make the pinches, basically. But in other courts, it totally clogs the docket. In Massachusetts, prior to this legislation, Massachusetts was the state with the most breathalyzer or breath test refusals in the whole country. We had it. Because of the way the structures had set up, there was a significant disincentive. Why take the test if you lose it for 90 days? And you got to understand that some of these defendants are not the brightest bulbs in the tree. And 90 days versus 120 days, for 30 days, I'll take a chance, I won't take it. And for years, I've been ringing the bell that they should give the same opportunity, that at the disposition of the case, the 90 stops and you start your 45 days. But with the 120, they wouldn't do it. Well, this is the solution to it. The problem with it is they make it so inviting that you're having a lot of people coming into your office saying, I don't care, I only had 1 or 2 beers and I can beat this thing in front of a jury. I don't want to walk for 180 days. I don't want to do it. And it takes a real strong person to get over that incentive. And I think it's unfair in that sense, that 180. But on the other, because you cannot get the 12-hour license until there's a 24-day disposition with a program. So that's the kicker. If they would give you a 12-hour license while the case is pending, it would solve the problem. Again, they don't call me up at night to ask how to legislate these things. But the impact on you folks as practitioners are that what you've come down to is analyzing the case. Yeah, you're going to walk for 180 days. However, if you get a not guilty, it won't be a first offense, and you don't have to worry for the rest of your life that if you get caught on this one of these things again, you have to worry about 2 weeks in a detox, and God knows what the penalty will be by the time you get caught a second time. and it's an insurance policy. You go through the whole business of why, if they have a defensible case, why they shouldn't plead out. And I have some real serious concerns on taking pleas. And I think the judge should, whoever the judge would be, in taking one of these pleas, and if they look at the report or they hear the facts and say, they must be asking themselves, why is he pleading out to this? The reason is the reality. The reality is he's back behind the wheel in 3 days. My big thing for the defendant is if I get a case from, let's say, Wareham, where they're now marking pretrial conference 2.5 months out, I will use all of my powers, as the Godfather said, and I'll have him in court in 2 days and get rid of the case. That's worth something to this person. What bothers me and what galls me is the person might not have been under the influence. And that's something that you have to be able to live with. So when you take the plea and the colloquy is asked by the court, did you do these things? There's a hesitation in a lot of these cases because usually the officer will exaggerate perhaps or enhance or give a distorted view. The court, I'm suggesting, has a duty to look into the cases that, and they know what the light ones are, they've been doing it a heck of a lot longer than us in terms of the number of cases, and to look into these colloquies. And then you're talking about almost like an Alfred plea situation. I have some very big difficulties with this. They didn't do it, but they want their license back in 3 days, and that's what's causing in this whole statutory scheme. I'd like some comments by the court, and Judge Coffey, jump in. I mean, I wanted to get your sense of this as well.
Well, in the district court, we have the admission to sufficient facts, and in an admission to sufficient facts, the defendant is not required to agree that the Commonwealth's case is true. And well, all they have to do is admit that if those facts were to be believed by the trier of fact, that the Commonwealth could prove its case by proof beyond a reasonable doubt. So in the district court, we don't commonly see the Alfred plea. We do see the admission to sufficient facts. And the reality is a lot of people will want to dispose of their cases.
Would you take a plea without an admission?
Without an admission, no. Would I put somebody on pretrial?
Not pretrial probation, but without an admission, but you find sufficient facts after listening to these facts as set forth by the Commonwealth?
No, I think in order to have a valid colloquy, you have to have the defendant admit that if those facts were to be believed by the trier of fact, be it a jury or a judge, that there would be sufficient evidence to find somebody guilty.
Since a lot of these cases are opinion crime, this is an opinion crime,
Right.
without a machine.
Right.
With an opinion crime. I mean, I've heard, we all sit around courtrooms waiting for our cases, and I've heard colloquies where even if the Commonwealth were believed, were insufficient. Are there times when you draw the line and say, wait a minute, is there more?
I think that as a judge, there are times where just by the recitation of facts, the Commonwealth has not made out all the elements. And then it's incumbent upon the judge to turn to the defense attorney and say, do I hear a motion to dismiss on count 3 because those elements have not been made out. But in terms of the strength of the case, again, in order for a complaint to issue, it's a low standard, probable cause. And as you say, a lot of it, it is based primarily on the observations of the police. So to answer your question, in terms of taking a plea, if the bare bone elements are present within the police report, as a judge, I'm not going to look behind that.
Mm-hmm. See, what makes it particularly difficult is, unlike an armed robbery, it's a gun. Point a gun at somebody, you can infer that that person's put in fear, etc. Those are cut and dry elements that are ascertainable facts. You get into whether or not alcohol impaired operation of a vehicle based on someone who got stopped for speeding. And by the way, speeding is not one of the indicators of someone who's under the influence. And all of a sudden, the officer smells alcohol, has him get out of the car, and has him go perform some tests on 10-degree weather without a jacket on. And in the weather report shows there's a 30-mile-an-hour wind that day, and he's asked to balance like a ballerina. And based on that, he forms the opinion. He could be wrong, okay? But even on those facts, I I know if I would make a lousy judge, I really would. I couldn't in good conscience take a plea like that, and you hear them. I'm not saying all of them, it's rare that they even get that far, they usually enhance it a little. But I have had cases where people insist on wanting to plead out because they want their license back. What do you do in a case? What is your obligation ethically? What is your obligation to the court? Because you're asked to sign off on that green sheet and say that he understands his rights, he understands all that stuff, and notwithstanding that, he still wants to go forward. And one of the parts of the colloquy, as you recall, is, do you think your lawyer's acting in your best interest? And if you've told him that you don't think he should plead out, and the guy says to you, you're not gonna drive me around to work, what do you say to something like that? So so you folks, unlike the judiciary, are put in that box every single day. And I'd like to learn what the solution is. I don't know what the solution is. Maybe maybe we'll get some insight from the judiciary, but I have a real problem with that. Judge Rufo, do you want to comment on that at all?
Well, let me.
Yeah, sure.
Okay, but just, I mean, this quandary, and I, it is an ethical quandary. It's not unique to OUIs, of course. I mean, this is something that happens all the time. But I think the bottom line is, as an attorney, you advocate for your attorney, you counsel him or her, but the ultimate decision is the client's. And you may think that the client is making a lousy decision, but in terms of your obligation, it's fulfilled by laying out the different choices that are available and the consequences of those choices.
Thank you.
You know, it was an interesting fact pattern. Dick has a case maybe in Wareham, and you can't get a pretrial conference for beyond the, it's 2 months down the line, and the trial might be 2 months down the line. But if you know the court you're operating in, a lot of the district courts, you can get your trial within 180 days. And I think if you know the court you're in, you get that police report. There's no breath test. You look at the police report and you say, there's no motion to suppress statements. There's no motion to suppress any empty containers of alcohol in the car. So you've got the dead up, simple, run-of-the-mill, operating under the influence, and maybe the officer gives him, he recited the alphabet correctly, but when he did the 9-step walk and turn, he was unsteady, stepped off the line. So you take the police report, and I tell clients, you don't have any motion to suppress statements, you don't have any motion to suppress any physical evidence. There are really no pretrial motions. Your case is right here, and it's a 2-page police report. You're in a court where it looks like you could get a trial within the 180 days, and I agree with Judge Coffey. That's the client's decision. You assess the case. Now you get to a court where you think you can get the trial within the 180 days. You might even want to make the decision on a first offense OUI. There are really no motions. You might say, I'm at the pretrial conference stage, or I'm going to waive this compliance in election. I don't need it. I can get my trial within 30 to 45 days down the line. If I win, he walks with his license. If I lose, it's a first offense OUI. It's not egregious. The judge should give him the 24D. He can go in and get his hardship license when he goes in the program if the judge doesn't make findings he doesn't deserve it. But when you look at the court you're in, and then you get to some courts, they don't let you waive the compliance in election. They force an in-court compliance in election. So when you go up there, you're on your pretrial conference, say, I don't need a compliance in election, can I get a trial date? Some courts will say, fine, you can get your trial date. Some courts will say, no, you have to have your compliance in election. So when you advise the client, you sit them down, and here's reality, here's real life. You got a triable case, you can win it. Here are the problems. You're in a court, if you're in Wareham, it's way down the line. If you're in Lowell, it's real difficult to get a trial date within the 180 days. They're just too busy. But if you're in a court where they're moving the cases, you can assess that and evaluate whether or not you can get your trial within the 180 days.
Let me respond to that. How many tried cases in the Boston Municipal Court? You show up there, you can't get in the doorway just to call the list. And this is the trial session. This isn't the arraignment session. You can't get in the door. It takes until 11 o'clock at night to identify who showed up. And that's the cops as well as the defendants, all right? So don't even start the day until 11 o'clock. Now they give you, it's such a disincentive to try a case there. They roll over backwards. if you have an OUI case that there is terrific. I mean, they think that that's like shoplifting. So that you really want to try this thing, and they then say, well, we have Judge so-and-so, so-and-so, and they ask you, what do you want to do? You want a jury waiver? You go here, and it's unbelievable. You don't have to try juries in Suffolk anymore because 90% of the time the cops don't show up. And they, the problem is the system from court to court, and I'm saying that respectfully, is bogged down and different wherever you go. In Wareham, you show up for a trial. They have 8 trials going that day with one other judge. And they pick the oldest case, or they pick the case where the person's from out of town, or there's always a reason why you're not going to get hurt. You're not going to get hurt. So I've tried that. I've been through it, and it's really frustrating because I try my cases, okay? And we all try our cases. It's one of the few crimes that the client hasn't hired you to plead out and make a deal. There's no deals on these things. It's so onerous that you have to try your cases. So what I'm suggesting to you is, I agree with Georgie. Know the court. Make sure you can get a trial when you want one. And if you want a quick trial, make sure that the deck is cleared. Find out. Call up 3 or 4 days ahead of time to see what's on the list, if they look up the list for you, and see what you can accomplish by getting a trial. And then consider going jury waive. They'll always jury waive a case for you. They'll find you, even if it's between. I've had cases that are tried, the same DA trying 2 cases simultaneously. And she'll try the jury, send the jury out, now she has to stop back on my case again, which is jury waive. How they do that, I don't know, but they do it, okay? So if you want to, one of the options is to jury waive a case. By the way, always find out what the answer is going to be. Make sure that your client's not going to be punished for going to trial. And I say that respectfully. Some clients are punished for going to trial, and that means that if they plead out, they go into the program more in second offenses than in first, but even in first with some particular judges. On a second offense, I always ask the judge in front, are you going to incarcerate him, or will you put him in a program after a trial? Because I haven't done my job if I don't know the answer to that. And I'll do it in the lobby, I'll put the judge right on the spot. And sometimes they say, I'm not going to tell you. All right? That's helpful. So now you have to go back to your client and say, you might walk out of here, but you also might go to jail for 60 days. Okay? So these are all the little nuances that the statute doesn't tell you, but the pragmatics of practicing law in these various courts will teach you, and hopefully we can share some of that. Anyone else have any comments
Just
on
to
the law?
jump in briefly, with respect, we all know that the court's dockets are bogged down for the most part, and certainly, at least from the Commonwealth's perspective, when one of your clients has an attack of conscience and decides to tender a plea, rather than take it to trial, the Commonwealth's always happy with
Once
that.
a prosecutor, always.
But honestly, I think besides, the question was asked before, are there times when pleas get before the bench and they're simply so deficient, and the facts just aren't there? I think you also have to look too, at least in a role as a supervisor of prosecutors, and I think most prosecutors are very good about this. There may of course be horror stories here and there, but we're also looking to see whether or not it's there and whether or not we can proceed to trial. Not simply, is this a defendant who simply wants to get back on the road so quickly that they're going to admit to something that's not there. So there are different levels, certainly, of safety and security to ensure that when someone is taking a plea or when someone is tendering a plea, there are actually facts there that would support it. The rest all just comes down to strategy, whether you want to wait that long for a trial, whether there are reasons why your client might prefer a trial as opposed to simply taking a plea. But I'll just throw that in there.
On the punishment aspect, on first offenses or second offenses, whether or not you're going to get the standard program, I think you have to look at a number of factors when you're advising the client whether or not they're going to be punished more severely. I always keep in mind the factors are, is there a breath test? How high is the breath test? Is there egregious operation? How egregious is the operation? What are the admissions? Is there an accident? How severe is the accident? You've got to tell them if it starts piling up and they want a trial, you've got to put it on them that this case is not a good case, and a judge may do something other than the program. On a first, I think judges still have to make findings as to why they denied the program. I think those are basically the factors on the first offense. On the second offense, it's a roll of the dice. It's you always go back to whether or not he's he or she is accepting responsibility, and if the judge is going to give you the 2 weeks. But, I think those are some of the practical issues. And this is gold, this, starting at page 5, this document that Judge Rufo produced for us. I copied it and put it in every OUI case that I have, because you can just flip to each section and find the change in the law. It's very helpful as trial lawyers on OUIs.
What I'd like to do now, this is, we could spend an entire day on this statute and its nuances, but that's not why we're here. What I'd like to do now is get some feedback from you folks. Tell us what are your concerns. We have a fantastic opportunity to talk to the experts. It's not, and as you can see, there's disagreement amongst us here. There's no one answer to this. It's still unanswered. None of this is appeals court tested. So I would like to get some of your views. I'd like to get some of your concerns. Yes, sir.
Has any analysis been done of other states that have had per se laws for some time as to how they treat the alternative theories or different offenses?
On out-of-state cases, I've only seen it come up prior to the per se. For instance, a person charged in Massachusetts with operating under the influence, fourth offense. The prior offenses are out of the state of New York, for instance. In New York, they have a graded level of operating under. They have, for instance, the first offense, I believe, is a driving violation, similar to New Hampshire. Then it goes up to being a person 08 or above, and then they have a regular operating under. It's a more egregious way. Now, I've seen it when, so you file a motion to dismiss so much of the complaint as alleges fourth offense and ask the court to reduce it to a first, because the New York statutes are not similar in nature, and I've been successful with that. On New Hampshire, I think everybody understands that the New Hampshire, if you charge OUI second or OUI third, and they're using a New Hampshire first offense, then that's not a similar offense to the Commonwealth of Massachusetts, because you have no right to a jury trial. It's a civil motor vehicle infraction only. The standard of proof is not beyond a reasonable doubt. It's a civil standard. So I've only seen it come up on motions to dismiss certain portions of the complaint.
Let me just raise one other issue that you've triggered my concern again with this particular statute. We've all had cases where you have operators from other states. One of my offices is in Cape Cod. It's in the town of Dennis, and so we get all of these tourists from Arkansas and from Texas. I mean, they come to Cape Cod for the first time in their life, and they go nuts. They get grabbed for OUI, and they want to go back to Arkansas, okay? The problem with it is there's this interstate compact that will give you the same punishment in Arkansas that Massachusetts will give you. If you don't go into a program in Massachusetts, what's the consequence on a first offense? It's a year loss of license. So now they go back to Arkansas, and they get this notice saying, wait a minute, it's a year. I only have to pay a fine in Massachusetts. So what do? Well, let's put them in a program, right? The problem is the new statute does not provide any longer for out-of-state programs. It used to be that under the old statute, you have an out-of-stater, the probation officer would usually have a book, and he'd call up the court where the guy lived and say, what kind of program that's similar to our program that could be acceptable to our registrar? And there's usually a program of some kind. Sometimes it's more onerous, sometimes it's less, sometimes you can do it on weekends or whatever. But as long as it's acceptable to our registrar, and they had a list of various programs all over the country. And it worked. You're a hero, you got the guy out, he's going back, you never have to see him again. And he goes into this program in Arkansas, and that's the end of the case. And this has to be corrected. I don't know how they're gonna do it, but they gotta correct it. The registrar will not recognize out-of-state programs. So unless this guy wants to get on a plane and come one night a week to Mount Auburn Hospital for 16 weeks, you got a problem. So be aware of that, recognize it, be able to advise on it, because there's no shortcut to it. It's legislated. There's no discretion. They will not recognize out-of-state programs.
And where it really, the people that are really getting hurt are the college students that go away to college. So if you have a client who's a college student, he lives in Wellesley, he gets arrested in Massachusetts, but he's going to go to the University of Arkansas or out west. That client really is never going to have the time to fulfill the Massachusetts program. He'll never have a 16-week interval of being home to do the program. He won't be able he won't be able to do the program out of state. So he won't be, when you come back, he's not gonna get his license back. Now, it's gonna be interesting how the registry treats it, because he can't complete the program, so it's gonna be, as Dick says, it's a year loss of license. But I'm not sure the registry's gonna give it back after the year, because I think they look for satisfaction that you completed a program. I'm not sure it's an automatic, you get it back at the end of a year.
If it's
So-
24D, if you take 24D where a program is required, you don't.
Right, so a college student living in Massachusetts, going to school out of state, just can't do the program, can't do a 24D. You're out of luck.
Yes, ma'am.
This is the answer to Jeff's
Oh.
question, but we did look at this, and like North Carolina, in terms of there happening the per se law, North Carolina says, if you're guilty of OUI, you shall be punished. OUI may be proved in one of two ways, UI or .08, and it clarifies the problem in the mass law. So I think there's gonna be some effort to rectify that, so then the jury instruction is clear. The crime is under the influence, and then it's statutorily defined that you can prove UI by either 08 or under the influence. And that's what we don't have in the statute, is one broad crime proved by two alternative theories. And North Carolina's written it exactly that way.
That was my question.
Yeah, so isn't Ohio, yeah, so isn't Ohio, California, and, what else did I see here?
I think there's like 7 of them.
Yeah, I'm just looking at, because I did look at Ohio, California, and Iowa. Those are, that just popped up when I did a quick Westlaw check to see, because we are the last state in the nation to have this .08 or OUI.
Sir?
Have you yet seen, heard from a judge who has required the Commonwealth to make an election? Because I've informally polled a couple of judges down in Plymouth County. I'm getting nowhere on that. I know that the Plymouth County DAs today are meeting at the Chatham Bars Inn, nice to have a nice budget. And they're discussing probably the same exact things. We're not electing, fighting this tooth and nail. Why would they want to elect? So you see.
No, it would have to be judicially imposed. They wouldn't do it voluntarily.
I know that, but
The
have
que-
you seen,
well-
heard many judges who say, you gotta choose?
As I say, my theory is no case before its time, so it hasn't been timely yet, but it will, and it's coming up soon. Yes, Judge? Judge Rufo?
I think it's fair in some instances that the Commonwealth elect, and I'm not saying that every case I would require this, but given the situation and the crafting of the motion in limine and the prejudice that the defendant might experience, that there may be instances where I would allow a motion in limine and force the Commonwealth to proceed just on one theory and give plenty of notice to the defendant up front, not on the day of trial, as Dick suggested, for sure, but as part of the pretrial, that would be an appropriate pretrial motion.
And I'm suggesting we do it before trial. I mean,
When they do elect, Judge, do you allow in, order, and staggering and everything else?
No,
If
all-
they elect 08?
No, they elect 08, it's Big Brother time. We take a look at the technology, we get Mr. Benjamin, we start doing the blood alcohol level, we take a look at cases like Commonwealth versus King, was the person prevented from going to get their alcohol blood content checked upon being released from the police station, Hampe, all that stuff comes in. And I have yet to see a case where the defendant was sober enough to know that they could go to the hospital to get, even though the police officers told them. We haven't had that, to go and get their blood drawn, because that's the corresponding thing that Mr. Benjamin's going to jump on with respect to the blood alcohol content.
Hey, Mr. Levins, you have a question?
Yeah, you're raising the issue of the unavailability of a program to an out-of-stater.
Correct.
Makes me wonder whether or not there are any issues of constitutional infirmity on perhaps a due process argument in that we're setting up a couple of different classes of people, aren't we?
The response would be, he has a program available, it happens to be at the Mount Auburn Hospital in Cambridge. And if he comes from Arkansas, doesn't he take his chances? I'm not saying it's fair, and I'm not saying it's correct. I don't know, and again, I leave it to my colleagues on the panel, that whether or not that rises to the level of a constitutional violation, in terms of equal protection or something like that.
Judge Coffey wanted to
Yeah,
comment.
Judge.
I think there is going to be a dramatic increase in the number of cases that we see where people are electing to take the breathalyzer, just for the reason that you stated earlier, that 30-day loss of license. And I think you also have to keep in mind that the person advising your client to take the breathalyzer is going to be a police officer at the station. But I think there needs to be a discussion, especially where a lot of our audience represent court-appointed cases and are not necessarily representing private clients, about the whole necessity to bring a motion for an expert. Because when combating, and I know there is going to be some discussion, lengthy discussion and examination of an expert, but at this point where we are talking about pretrial motions, I do think that it's something that all attorneys, where there is a breathalyzer, that you bring a motion for an expert. And that also ties in terms of asking the Commonwealth to elect upon what theory to proceed. All judges in the Commonwealth are very cognizant and sensitive to the cost of litigation. And I think it's a very persuasive argument to make before a judge. Please, judge, I'm asking the Commonwealth to elect what theory to proceed on, because if they're not going to go forward on the breathalyzer theory, or then clearly my motion for funds to hire and consult with an expert need not be addressed. But if they are, then at this point in time, you are going to have to commit to $2,000 or $3,000. So that ties into what
That's an excellent
previously
point.
discussed.
By the way, how many here do court-appointed work? Okay, yeah, I think it's a fantastic approach. Yes, sir.
Judge, I think your suggestion doesn't only apply to people that take pro bono cases or doing court-appointed work. I've had plenty of clients who could barely afford to hire me, and then they're broke. You know, their family chips in the money, and they can certainly qualify as an indigent or as a person below the level. I frankly don't see most district court judges getting their counsels paid for. I don't see them granting a motion on that. I just think that it wouldn't happen.
Yes, sir. Keep your voice up, please.
Yes, as to the programs, I hate to jump around.
Yep, go ahead.
It's my understanding they're all developed throughout the country from DOT criteria.
Correct.
So how come Massachusetts program is, you know?
It has to be corrected legislatively. For some reason, it wasn't done. It was an error. I don't even know if it was intentional, but if it was, it has to be corrected. I agree with you. There are programs everywhere in the country that would be acceptable to our registrar.
The same.
Right, well, they're not exactly the same. But the point is that the statute is specific. And so that statute has to be corrected. And I've been told it's going to be, but I'm not gonna hold my breath about it. Yes, sir.
Does that, from what I'm hearing, am I hearing that a judge might be more inclined to pressure the Commonwealth to make an election because of economic considerations with regard to hiring an expert? Because if that's the case, then legal decisions are being made based on cost economics and not on whether the decision is legally supportable or not.
But that's reality. I mean,
Right.
that's.
So basically, everybody should go ahead and make the economic argument. We're gonna have to go out and hire an expert, and you wouldn't want that to happen because it might cost the Commonwealth a lot of money.
No, you're simplifying it. All I'm saying is that realistically, that is a factor that all judges look at, and that in terms of presenting a persuasive argument, that is something that should be advanced.
It's not really a factor though, Your Honor, because there'd still be a breathalyzer and there'd still be an inference. And so you'd want to attack the breathalyzer even if the Commonwealth elected a theory. Even if the Commonwealth elected the alternative theory, you'd still be faced with a breathalyzer. So there's really no economic issue.
Mr. Ryan?
A couple of things. You mentioned that you asked for a show of hands, and I was in the front, so I didn't see it, but it's about half-half under 5 years, correct? A lot of these people don't have the reputation of some of the people on the board and even some of the people in the room, so it's gonna be hard for them to try to justify getting a whole lot of money to try an OUI case, especially some of the people in they do public counsel service. I just say that because I think this class is great. I think it's probably about 5 months too soon, not on purpose, but because we just don't know what's gonna happen. Whether somebody's gonna take it up, if there's gonna be a ruling from the SJC, if they've been bogged down with Judge Cowan and Judge Marshall and the other two about what's gonna happen with marriages. I don't know what's gonna happen. But I did it once, and I have a suggestion that I just wanna try with the judges. Suppose John Doe is arrested for operating under, and he doesn't take a breathalyzer test. So he appeals to the registry, and he loses. They lose 9 out of 10, probably. So you file your $195, and you appeal to the district court, and you get a hearing date before a judge on the appeal of the loss of license around the same time as the pretrial conference date, because you can almost do that. What would be wrong, because under the new OUI hardship law, you have to pay a $500 fee to get the license reinstated, just for the 12-hour hardship. If it was a really close case, no accident, family man, the whole 9 yards, everything that goes towards the first offender that you look at. You come in with the appeal, and you have a lobby. Judge, maybe this is a case where you might think to overturn the registry ruling. And if you do, my client is willing to offer a green sheet stat.
Well,
You don't lose your license, you turn in for the 45 days, you don't have to apply for a hardship. You save $500. And the other thing, you don't have to go into the program right away. I mean, under the hardship law, you have to go into the program. Here, you've got a guy that's gone into the program, doesn't have to have a hardship license for, because the registry's not running them, the registry will run them concurrent, but it's 180 days plus with the 45.
that is
What would be the problem with it?
one of the problems is the standard of review.
Well, no, I know. I mean, you're in the lobby. You already told me that you go in there into the lobby and you say to the
He doesn't
judge-
come into my lobby.
Well, I know that, but, he's gone into enough.
He doesn't want me to pick his pocket.
Are you gonna send him to jail if he tries a second offense OUI? You get a feeling. And if the judge reads the report, the judge reads the report and says, this is really close, meaning on the facts of the OUI, your client then is not under the gun to admit when he really doesn't want to, but he wants to save the license. Now you've got maybe some way of both sides, Commonwealth and defendant, having an out.
Since I'll never be a judge, I'll ask
I did
Judge
this in
Rufo.
front of Judge Bruder, and repeated it, he went with it.
Yeah, well,
Exactly.
I'm not saying it's, you're trying to get around what Mr. Patalaro might do, but you're certainly getting around what the statute was intended. You take a breathalyzer, you get a license in less than 30 days. I mean, we used to do that all. The guy had a .22, you'd walk him in at arraignment day and plea him out.
Right.
Or wait to 15 days and plea him out and stop the 90 and start the 45. They'd jump on that in a heartbeat. Now you've got a different thing since July of, I think, punishing people that don't want to take the breathalyzer for whatever reason. And I've got a case here, I just showed my next door neighbor here, where Wayland is now sending out information that the breathalyzer machine for 9 months wasn't following 501 CMR
That's right.
regulations.
That's right.
So notions for new trials are being allowed sui sponte in Framingham Court. I've got 2, as a matter of fact.
They didn't do that voluntarily, by the way.
No,
That
I
was as a
know, I
result
don't
of
know
the
how they
case.
did it, but I haven't
Result
checked
of a
into it
case.
yet. But I'll ask you later, because I've got 2 that I'm going back in on. But I'm just wondering how the court feels, and I know I'm just hitting it with them, but just as a first impression, does that sound like something that might, I know I'm talking to Judge Rufo and Judge Coffey, who are usually on the same page in most cases, but not always, but,
I'll take that as a compliment.
it is. I had a jury wave with you, thank you. So, I mean, it does work sometimes. So I'm just wondering how that would sit.
I'll take the first stab at it. I think that the statutory scheme is clear, that a defendant can proffer or tender a plea at any time at a judge at any step of the stage in the proceeding. So that in your factual scenario, what's precipitating it and the motivating factor, happens to be as a product of the new law. I don't see that as a problem in terms of gendering a discussion. In our case, in my case, and Judge Coffey's the same, we don't have lobby conferences. We're just too busy to do it. We don't think it's a good idea. We do everything on the record at sidebar. So I would feel comfortable discussing that at sidebar, and if that was one of the factors or features that you thought was in the best interest of your client, and I felt comfortable in terms of accepting that plea, because we do get the final word on that, then that's a disposition that I would certainly listen to. I don't know how Judge Coffey feels. We haven't talked about it.
No, we haven't, but I'd see it as a viable disposition. And a lot of it would have to be the facts and circumstances
Obviously.
surrounding the arrest.
No, I
And
mean,
whether-
you had a serious accident.
Right, and
forget
whether
it.
this person, the bottom line is the judge has to make a determination of whether that defendant represents a risk to the community and/or himself. So if you can minimize that risk, then I think what you are suggesting is appropriate and viable.
We have 8 more minutes before the break. I want to get as many people who have concerns to express them, because now's the time.
Dick, just to follow up.
Sure.
I'd want to see him in the program, though.
No, I
Because
agree.
that's going to be.
That was my first, that's what I
Yeah.
said. Judge, at the sidebar,
Right.
the civil case, you overturn, and then here's a 24D green sheet that we're prepared to do in the next 2 minutes.
Right, but no delay, because that's the.
Well, you take it under advisement anyway.
That's the comfort factor.
The civil part of it.
Right.
So if he doesn't do it, you don't overturn the registry.
We don't like cases that come back.
That's right.
Yes, sir.
I just want to, I may not be reading the statute right, but is it possible to get an arraignment asked for conditions of release under the pretrial probation statute to participate in the 24D? You're on probation, you've taken the 24D, and then shouldn't you be eligible for a hardship license?
I don't understand the question. You're pleading out at arraignment?
As a pretrial probation condition,
Ah,
right?
Condition of release.
Why not? And then you're not squeezing your guy into a plea. You can take your time and
That's
defend
a
your
very
client,
true
and he gets the benefit of potential hardship license.
I don't think the registry's even considered it. And the way I read the 24D hardship license materials that came from Andy Padalaro's office, that wasn't suggested as a viable disposition. They want the case to plead out.
But isn't the goal for rehabilitation and
Yeah.
quick kind of attention to the whole problem? It just doesn't seem to.
inherent in the statute, it's clear that the intent was that you can apply for this upon entering a program pursuant to this section. And this section implies
A plea.
a disposition.
That's what the hardship says in the registry. It says you got to enter a 24D program.
And
Right.
24D
I like
speaks
the
for
idea,
itself.
but
Yeah.
but the hardship,
Charged with or charged with OUI, all through the statute, it says charged with or convicted of.
I think it has to be subsequent to disposition.
Yeah, because would
Doesn't
you need
say
an
that.
RMD, would you need an abstract? The court would have to send something
Referred
to
to
the registry,
no,
which is
the only-
pretrial probation, if you're generating paperwork from the court to the registry. You're not gonna have that little, you know, you gotta have that little piece of paper.
The papers from the 24D program that they have to bring to the hardship.
Well, no, but the abstract saying,
They have the paper.
That's, the only direction about an abstract is that probation has to.
By the way, let me address that so you all understand it. Most of you have already done this, but I want to make sure that it's clear. The statute says immediately, but immediately is not immediately. What has to happen, they will not allow that day your client to take a certified copy of anything to the registry. There has to be an enrollment. So what happens is you send the client over to the program and have them get a letter on their stationery indicating that they are enrolled. In the meantime, the computer will have notified the registry, or the fax will have notified the registry. It's a 3-day process, 3 business day process. You can't rush it. It's our taxpayers' dollars at work, 3 days. You also, most registry officials will require some kind of evidence of the hardship, such as employment or medical need or education. So if you need a letter from an employer to show you're working, you need something over and above the letter from the program. So I want to make sure everybody's clear on that. It's not, immediately doesn't mean immediately.
It's on page 4 of the Chief Justice Zoll memorandum. It's in your materials, paragraph number 8.
Any other questions? Yes, sir, in the back. We'll get to you.
That gentleman's hypothetical about having the district court judge overturn the registry. It sounds really a good good strategy. But in reality, would the Commonwealth appeal the district court judge? And then where's my client stand 2 years out after the appeals court finds out that the judge really didn't have the authority to do that under the standards of review for overturning the registry's decision?
I don't know the answer to that.
The DA's at the
Yeah.
sidebar. The DA's at the sidebar. He's got to try to move cases, and this one's on the cusp of maybe going either way. He's gonna get rid of the case. I guarantee you, in most cases, in most courts, especially the busy ones, they're gonna dump, they're gonna get, and I don't mean that badly, not dump, they're gonna get rid of.
Resolve.
They're gonna resolve the cases. I mean, the perfect scenario is a guy with 5 kids, been working 40 years, no prior problems, no accidents. So everybody knows the litany of what you can do. I mean, you've even done it on a jury waive trial.
The DA is gonna reserve their right to object. They always do, or they're gonna stay silent, then they're gonna go back to their office and go through the supervisors to figure out whether they screwed up or they didn't screw up or whatever.
Well, technically, the DA's not even in on the civil appeal.
Sir.
Technically.
Dick, on the 24D hardship, where somebody gets in the 24D.
Right.
As a first offender, but
Yep.
they've got priors with the registry, but they're charged as a first offender.
Yep.
Any experience with the Board of Appeals on overturning
The registry knows how to count.
So I know
So if
that.
they have they have an in-state prior OUI, but they're only charged with a first offense for some reason, they didn't pick it up, or they didn't want to amend, or whatever, you're looking at a second offense. And you're looking at not getting your license back, period, end of story, until there's an inpatient program. So you have to go back to the court and resolve it at the court level.
But
Okay?
the court has ordered 24D first offender.
Correct.
Got the piece of paper.
And you try to get your license back. It ain't gonna happen.
Even the Board of Appeals will shut it down too.
Have
Not gonna
have
happen.
your client go in before you do it. It depends on the age of the case also. So if it's a real old OUI in-state, before you do anything, have them go get their driving history, because it depends on how old it is, whether or not it's going to, it may be at the Board of Probation. I've had a few of them, where it's on the Board of Probation check. It's 17 or 18 years old, but when you go to get your driving history, it's not showing up. Your driving history is coming back without that. You get a judge to give you the 24D, the registry will give you the hardship.
Last question. Yes, sir.
Attorney Zipson, as the district court judge granted your page 53 motion yet? And if so.
Which page, page 53, is that the one to elect?
That's the notice of intent.
I filed them, as I say, no case before its time. My cases are not old enough yet. It's not even, Alicia's from my office, she knows. We have cases, we can't remember what the clients look like. So,
Waiting for another judge, say it's the Supreme Court to.
no, I'm suggesting it's a viable. In fact, we'll be filing one in the next couple of weeks. I have a couple of them coming up. And the problem with it is that unless it's been done before, judges are gonna have to, I want them to reflect on it. I want them to think about it. DAs are not gonna voluntarily do this. The impact of it is if every one of you start filing these things, DAs might start thinking about it, because you're gonna have a disparity. By the way, I find out from Judge Rufo, and I don't think I'm revealing any confidences, they don't get any training in this. And the impact of the statute, which seems to me incredible, because it's the vast majority of the docket of most district courts, is the implementation of this particular statute. And we're fortunate to have 2 justices who I can have great confidence in will do the right thing. But some of their colleagues take a view that unless I've been told to do it differently, I'm gonna do it a particular way. Yes, sir.
Briefly, under the statute, in the new statute, if you're convicted of operating under the influence of drugs,
Yep.
you're now eligible for the 24D program.
Yep.
I had someone in Lowell a couple of weeks ago, and is there any program?
Find a program.
But an alcohol program.
Why don't you answer that, Jeff?
No, I think in that case, you really want to get into the more well-known programs like STEP, or some treatment provider that's going to have a period of inpatient and outpatient programming that the court can rely on.
Has to be acceptable to the registrar. They're the key.
Right.
So you can check with them. I mean, I'm sure,
If you found a program, if I found a program acceptable to the registrar, that might be less onerous than a 16-week program.
as long as the registrar accepts it.
But
And
the
you
court
can-
also has to accept it, too. Yeah.
Yeah. Okay, why don't we take a break? We're going to be back at 10:45. We're gonna have you're gonna have an opportunity to ask questions throughout the day, so we're gonna talk about discovery. That was good, Judge. Good job.
We disagreed. Yeah. Well, I knew we did, just by the way our conversation.
Yeah, I can.
Excuse me, Judge, can I get a copy of that before you leave? I can't get one.
He wants one.
I know, I can't, I'll tell you how I got part of a copy.
Yeah.
I stole it at 4 o'clock on Friday afternoon, to the court, had the court on, the custodian beat me Saturday morning, so I put it back. George, I tell you, it's a great book.
Yeah.
I'd love to see it.
Yeah. Yeah. Oh, but do you want to get into that? The discovery part? That's one of the things that I can do is a private motion. To ask. Or do you wait? That's interesting. Or do you sit and you wait?
Walsh was there, Jimmy Sullivan was just there. He's a good guy. Well, I mean, what do you, I mean, our wife. You run here. You run? Who said you were Chris?
Just took those that chunk and gave them to us.
Then you just go through it on the
Yeah, yeah. So that's.
But here right now, if you take a look at your cases, what's wrong with that?
Yeah, I know.
Basically, you don't get into the trial. So you're going in there, is it going to the judge? He says, Boom, $180. Yeah, but if you there's two ways you can represent money. And I didn't mean to be critical about being now. They should give everybody a free pass, 2 years from now. What's going on? It's going to be difficult, it's going to be different things. No. Do you know what I'm saying? Here I saw this
Yeah, different rules.
I'm really sorry.
They didn't identify him.
Yeah, no, and I told him the problem is, we live in a real crappy.
Most offices are now
How are you? Just recited the alphabet. How are you?
Oh, I don't know.
Like my guy. Oh, Margaret Marshall was as awesome as she always is, and but the rest of them, especially Sasha, I was really surprised. So, but she was an ugly murderer. So.
Thank you for your nice letter, by the way. You sent me a
Oh, yeah,
very
send
sweet
it.
letter. I
Yeah.
appreciate it.
You did a great job.
Thanks.
I'm sure you are, but you know what? Right in the backyard, nice. You like Rich Saviano. He says the same thing. He's in Brockton. He loves it in Brockton. And he's there. Yeah.
Daughter calls on Monday, you know, she's sick. Come and get me.
Hello,
You
how are
made
you?
it.
I did.
Good
Of course,
to see you,
no
thank
problem.
you. Yeah.
Good to see you.
See you, all right, we'll move you over. We'll move
All right, you tell me wherever I'm going. That's all. Doesn't matter.
Just
Anywhere.
push you in here.
Actually, there,
Well, are you on again too?
All right. No problem.
Actually, you're not really on again until the afternoon.
Oh, okay.
But you can, why don't we,
I
come
just
over
sit
here
here and
with the,
listen. I can sit here.
with
I'll tell you what. I
the,
can sit right over here. How's that?
all right, that
Right in the corner
balances.
there.
Okay,
All right?
and then we,
Yep.
but if you do want to say something, Kevin, just, we do share his microphone with you because we are recording.
Oh, I don't know if you can do that. It took a while that to happen.
You're doing some examinations, we thought, we'll give you a lavalier mic and you can stand in the middle.
Yeah, no problem. Yep, anything you need.
When are you doing?
The arresting officer, and then one for, see, I want to get the sheet thing too.
Well, after George does his opening, I'll get the
Very good.
lavalier mic before we do the lunch and we'll give it to you. And then you can.
Oh, whatever, no problem. Oh, that's fine, I'll be here.
All right, okay, thank you.
Glad you said that.
Hello there. I'd like to thank you for your
Hey,
invitation.
how are you? Good to
I'm
see
just
you.
fine, thank you.
Good,
It's
good.
nice to see you. It's always, your advice is always appreciated.
Well, good, thank you.
Thank you for,
This one's worthwhile.
very much so.
This one's worthwhile.
Very much so.
So you do a lot of this stuff?
Well, it depends what walks in the door. It's not like
Yeah,
you that this is.
Yeah, well, there's a lot of it. Yeah, we do everything, but this is the fun one. I enjoy this one. Made some notes and I can't find them. I know this stuff.
It's gonna be a real good day. Yeah, and I thank you.
Good, thank you.
Yeah.
The woman who's recording first said that some of those people were not being picked up on the recording, so I guess you either repeat the question or maybe
will.
just ask them to speak louder.
Yes, I will.
Otherwise, we have to run around with the microphone and it gets a little awkward.
Absolutely.
And Kevin is here.
Kevin is here?
Yep, he's here. So let's
Okay.
get started.
Yep.
See if I can get everybody back in.
Okay.
As happy as I love. We lost them.
Having too good a time. Need a picture?
Yeah, forget about it. Everybody have a section.
Okay, yeah. They just work for me. It's the work of my house.
If you could all take your seats, please, we'd like to get started again. Thank you.
Okay, I'd like to get started if I could. Why don't you have a seat? By show of hands of those who are here, how many have ever heard of 218, Section 26A? You're for it today. I don't see anyone. 218, 26A, one. That's it? Okay. 218, 26A, a copy of which is on page 47, is the best thing that ever happened to the defense bar in the district court. This statute is the statute that eliminated the de novo system. But buried in the statute is a compromise that the legislature made to the defense bar. I am old enough, and many of you are old enough to remember, that you were not entitled to police reports as a matter of right, and depending on the proclivities of the particular judge, you'd have to fight like hell to get them. And I actually tried cases without police reports. And there were techniques of getting the report the day of trial by showing that the person used it to refresh his recollections. He had a right to look at it, and you had to do a speed reading thing to read the report for the first time of the day, during the trial. 218.26a eliminated that. And in the bold section, it sets forth that a defendant is entitled and also requiring, it talks about the requiring the defendant, the court on its own order or on the motion of the defendant, would require that the defendant be permitted to discover, inspect, and copy any material and relevant evidence, documents, statements of persons or reports of physical or mental examinations of any person, or of scientific tests or experiments within the possession, custody, or control of the prosecutor or persons under his direction and control, which has been translated to mean the cops. Upon motion of the defendant, the judge shall order the production by the Commonwealth of the names and addresses of prospective witnesses and the production of probation department, by the probation department of the record of prior convictions of any such witness. This is absolute pure gold, but most of you are young enough that you've grown up with it. You grew up with computers, you grew up with video games, and you grew up with the statutes. So you don't realize how hard us old-timers worked to get this stuff. Now, if you look at the omnibus discovery motion, you don't have to look at it now. What I did is I crafted a motion that asked for every possible thing that could be relevant to the defendant's arrest and circumstances. Now, the DAs initially would say, it's too onerous, Your Honor, it's too burdensome. Well, the test is not onerousness or burdensomeness. The test is relevance. If it is relevant, it is discoverable. As a result, all the field sobriety testing manuals that particular officer used, not the current one, but the one he was trained on 10 years ago or 8 years ago, are discoverable. It's reached a point now that I just send a letter to the Criminal Justice Training Council, and they tell me when the person graduated, from what training academy, and what number of the manual, because I have all the manuals. So rather than them ship me the manuals every time, I have a whole library of manuals. You just tell me the manual. I then, on the stand, get the police officer to agree that that's him. By the way, it's very interesting. Police officer will get on the stand and say, and the DA doesn't check, says, how long have you been a police officer? 8 years. But he counts like 6 years as a security guard at the mall. Okay? And I said, and I'm looking at the thing, and it said he graduated 1.5 years ago from the state police. My first question on cross, are you the same person? And you graduated this police academy, and they don't think that you would have that stuff. And as a result, credibility is destroyed. That was the end of the case in that particular situation. All through discovery, and we'll get into how you do that in a moment. So relevancy is the test, not burdensomeness. On the other hand, it says, shall be available for copying. They don't have to copy it for you, and they don't have to bring it to your office, and they don't have to put it in a nice, neat little package, although some DAs feel that they have to do that. They don't. What it is a pain in the neck. You got to make sure, a couple of things, and what I suggest. When you look at that motion in there, that's in volume 42 of the Mass Practice Series, that covers just about everything on an OUI case, and you file that, and it's being filed all over the Commonwealth. So I go out to Palmer District Court, which I go to once every 14 years, and they see my name, you're the guy with that motion. Everybody's filing it. So now it's more or less part of the practice. The point is to make sure the motion is incorporated into the pretrial order. Either you staple it, carry a stapler, and get them to agree to it, or you write out every single thing that you've agreed to. So that's part of a pretrial order. You get a copy of it signed by the judge. Then you have the DA call the cops and say to them, make an appointment for this lawyer. Now you have a court order, and you have an appointment by the DA, because the police they don't understand 218.26a. They don't give up anything. So now you're at the police station, and they don't want to give it to you. You have a court order. You have a right to subpoena that person in before the court, and have him ask the court why he shouldn't be held in contempt. Doesn't have to get that far. Just knowing what you can do if you have it properly postured. On the other hand, like the Middleborough State Police Barracks does with me, they refuse to let me use their paper. So how many lawyers drive around with reams of copy paper in the trunk of their car? Okay? I do, because I've been through all of that. And it's reached a point now where we're at a standoff. I now get usually everything I want delivered, because I can usually get to a supervisor. The next thing you know, there's a trooper that drives up to my office. Is this enough, Mr. Zisson? Would you like more? Et cetera. It took me a long time to get to that stage. Every one of you who reads 218.26a and understands that it's a matter of right and not because they're nice guys, you can put the thing and posture the thing in such a situation that you're going to get it prior to the trial. Now, one of the things you want to ask for is all documents that the Commonwealth intends to introduce. And you want that 30 days before trial, not the day of trial. And you want to put it right in your pretrial order. Why? Why? Because one of the documents they're going to try to introduce on a multiple offense on a bifurcated trial, meaning they have to prove second, third, fourth offense. And by the way, in the materials, the last paragraph of 9024 says that they can use certified copies of probation records, which is scaring the hell out of me. Unless they give it to you 30 days in advance, it's precluded. It's precluded. Before that amendment, they had to bring in a live body or some way to identify. The probation records have to be able to have a social security number, a date of birth, something that is presumptive that that's the same person. Now, this is only for in-state, not out-of-state. Out-of-state, they're going to have to still bring in a body. But it's in the statute, and it's in the materials, that paragraph out of 9024. So, back to discovery. You want that, and if they don't have if the certified copies come in on the 10 days before, or they try to give them to you the day of trial, they don't come in. They don't come in the end of the case. Because it's within, of course it's within the discretion of the court to let it come in late. But a court would be hard pressed to do that when you set it up so perfectly. And if a judge is abiding by his own orders, and you make that an order of the court, he's precluded. Especially on something that's so important and so dispositive. The judge might say to you, by the way, that's a third offense. Minimum mandatory 150 days. I'm going to give him the same 150 days. Why you want to go through the exercise? Why? Because unless he's convicted of it, it's not a felony. Even though he does the 150 days. Unless he's convicted of it, he cannot He could participate in all the programs of the institution, including work release, bracelet program, all that stuff, which he would be precluded from participating in if he was in a third offense, because he got to do every day except for his mother's funeral. He's got to do every day. Don't have to do that, because it's no longer minimum mandatory. 150 days no longer means 150 days. If you can get around that issue of them proving he was the same person, it all comes back to your pretrial conference report and discovery. Okay, so the next question is, everybody understands it, by the way, 218.26a. Gotta be relevant. You have to go to the, by the way, you learn all kinds of stuff from going to police stations. Don't look at it as onerous. Look at it as an opportunity, as education. Because I've gone to police stations, they say, oh, you got one of officer so-and-so, what a flake, this is what he does, and they don't like each other, they're like, oh, ladies, you find out all kinds of stuff. One of the things you ask for is something called the audit sheet. Now, Chapter 90C requires, it's a no-fixed ticket law, that they keep an audit sheet, and they're not disclosing atomic secrets. It's public record. The Boston Globe can go in and get it. It's a public record. It's in the statute. It's a no-fixed ticket law. But it gives you a sense of how many tickets this guy writes. Now, there are some people, there's one particular trooper who goes, testifies in Somerville all the time. He pays his mortgage on 2 pinches, 3 pinches a week for OUI. That's where he makes his money, because he's a night officer, he gets his court time, and he grinds every one of these cases. And every one of his reports looks the same. Every one of his reports looks the same. You want some of his other reports. And you get that by talking to other members of the bar about who this person is. It'll pop up on the audit sheet. You'll see. Most audit sheets, if they make 1 pinch a week for OUI, that's a lot. But if you see one making every night, no cop is that good. They're not that good. So there's something going on there, okay, with this particular officer. There used to be a cop on West Rock Street before you folks were judges. And he was notorious. Everybody knew his name. He made me a ton of money, okay? Paid for my kids' braces, all at the same cop. And I had all his reports. These people would get there, represent the people in the same neighborhood, and they'd come to me. All of this is now, it wasn't at the time, now discoverable. So, what are the things that you look for? Well, first of all, it's basic stuff, and you can go through the list, and I'm not gonna read you my own motion. But some of the more unknown things are the booking materials. By booking materials, it might be an envelope that they put their valuables in. Then they put down the time. The guy who is the turnkey, his life's work is making sure the guy doesn't escape, making sure that the guy doesn't commit suicide, and to make sure that he isn't accused of stealing. So his times are going to be accurate. But the cop in his report, and the citation might have one time, the report might have another time, and the guy in the station could be having the time when on the report, the guy's still out on the road. Those are issues of reasonable doubt which you would never have come across had you not asked for it. What kind of envelope? How can an envelope be important to someone who's under the influence? Goes to the credibility of the arresting officer if it's inconsistent. You never know. The more material you get, the more stuff you find. And the DA is at a disadvantage because you think they go and make copies for the DA. They never do. They show up that day. The DA has 9 cases, all of which are set for trial. If you're lucky, he scanned the files the night before, so he knows the names of the players, talked to the witnesses maybe over the phone. And the DA doesn't know. It's like lottery. Like I said to you before, they'll try 2 cases at once. One jury waived and one with a jury. How the heck do they keep track of it? They can't. You have an incredible advantage. That being the case, you have to know what to ask for. Now, Dr. Benjamin is going to tell you about the machine. You have to know what to ask for in the machine. Now they have it where you're going to be able to do it online. You're going to be able to find everything about the machine, but not enough. What they want to give you is never helpful to you. It's never good, okay? They want to tell you that your client blew a .19 and that the machine is wonderful and the simulator is terrific and everything's jived and the computer chips worked and all that stuff. However, they don't tell you that there's a guy it's a Draeger machine. There's a guy in Germany who's president of the company who testified before a Dober hearing down in New Jersey who says you should only use the machine 45 times a month before it starts to fail. Well, that's one test. We do a 2-test protocol. That's 22 times a month. You do it more than 22 times a month, the machine is vulnerable. Do you think they tell you that? Do you think Nancy Burns will tell you that it's vulnerable just for that reason alone? He's going to tell you all kinds of stuff about people blowing into the machine. As you get older, your ability to blow into the machine becomes more difficult. And these so-called insufficient samples, the significance of that. Well, you have to know what that's all about. So you need the manual from the machine itself, not the one the state police publish, because that's proprietary, excuse me, because that's what they want you to see. It's part of their infrared breast testing course. All this stuff is foreseeable that it will get into the defense hands. It's all very self-serving. You want the one that the machine manufacturer publishes that talks about all of the warranty claims and all the disclaimers and all of the added options. If you don't have this, you can't do this. You don't have a mouthpiece that does such and such, you can't do this. You want all that stuff. Think about cross-examination on this flawless, perfect, wonderful machine where they're changing the models every 6 months because of their new and improved versions, okay? So all of this is discoverable. If you have a blood case, you want the chain of custody, you want the protocols, you want all the stuff that involved with the blood. There's a whole issue on blood. And Kevin will talk very briefly. By the way, this is Kevin Reddington, see this distinguished gentleman sitting right there? He sat the longest with his mouth shut that I've seen him since I've known him. But he will enlighten you on this, and I'm gonna have him join in a minute on the discovery business. So, be as creative as you can as long as you can tie it into relevancy. As I said, audit sheets are very remarkable in telling you who the police are and what they're all about. You want to know everything that the defendant signed. You want everything that relative to the case. Plus you want the log. It's something called an administrative journal. Boston Globe sued the police departments in the past and was successful to show that that's a public record. So they're not giving up anything. So you're entitled to a non-redacted version of the log in the administrative journal because it's a public record. Now, why is that important? Because it gives you, it gives you roll call. Simple thing like roll call. You want to know how long the cop has been up? You might be on a second shift. He might be up for 24 hours straight. He's blurry-eyed. He doesn't write his report for 3 or 4 hours after that. You want to know that. You want to know where the other officers are. You want to know if they're on other calls. You can say, I was assisted by Officer such and such, but he was on the other side of town, according at least to the log, and the log never lies. The police are laughing up there. They know that the log never lies, right? Anyway, the point is, you want this stuff, and you might want to run it by some law enforcement friends to have them interpret it for you. You'll find out stuff, but they can look at things and say, wait a minute, this isn't right because of. Just like you use an expert witness as a doctor who can interpret things on a medical report. They'll see things, if you're new at this, on a police report that you might not be obvious to you. Okay. Any questions on discovery itself? Because I want to have Kevin join in on this, but on the issue of discovery. Everything relevant is discoverable. That's the test. Not burdensomeness,